Good evening and welcome to Lawyers on the Line. I'm Jim Balmer, a founding partner in the law firm of Falsani, Balmer, Peterson, Quinn, and Beyer. Tonight's topic is litigation safeguards. We've all heard a great deal in the last few years about frivolous lawsuits, too many lawsuits costing the society a great deal of money. President George Bush talked about them in his 2005 State of the Union speech and how they are harming the American economy. Is there a real problem? And if so, what are the courts and legislatures doing about it? Have safeguards against frivolous lawsuits been effective? Here to discuss this, I'm pleased to welcome tonight's panel. Judge Eric Hilden, a judge with the 6th Judicial District, chambered in the Duluth Courthouse. Judge Michael Kuzo, also a judge with the 6th Judicial District, chambered in the Lake County Courthouse in Two Harbors and the Cook County Courthouse in Grand Marais. And Sean Quinn, one of my partners at the Falsani Balmer firm. Judge Hilden, Judge Kuzo, and Mr. Quinn will respond to your questions about litigation safeguards. Call locally at 788-2844, or if that's long distance for you, you can call our toll-free number at 1-877-307-8762. And now for our first question. I got what I consider a frivolous lawsuit in the mail. What can I do about this? We'll start with Judge Hilden.
Well, the first thing to do a lot of times is call your insurer. Depends on what kind of case it is, of course. I mean, if it's a auto accident case, obviously you'd call your auto accident insurer. But a lot of people are surprised that they may have coverage for different types of lawsuit through homeowners insurance. And if you have coverage, then the insurance company will hire a lawyer to represent you.
Well, what'll that cost me?
Well, if it's part of your insurance, then that won't cost you anything.
What if it's a contract claim, Judge Kuzo? What if I get sued for some claim of breach of contract, and I consider it a frivolous lawsuit? Can I get insurance to cover that, or do I have to spend my own money defending myself?
I think in most cases you probably don't have insurance that would cover that type of situation. Many cases that end up in the district courts of the state of Minnesota are businesses making claims against other businesses. Most often, those are those contract claims, and there isn't insurance that covers that type of setting. There may be some rare occasions where you actually do have some insurance coverage. Again, you may have some claims against your insurance company in an auto accident-related claim. There may be some insurance coverage that ultimately you could be reimbursed for hiring an attorney. So it really depends a lot on each individual situation.
Well, Sean, do I always have to hire a lawyer when I get sued?
Well, no, of course you don't. And in certain situations, what we call small claims court, conciliation court, where the matter is under $7,500 in value, generally the courts don't want people. Is it 10 now?
10.
No, it's 10. It's 10,000.
Going up to
It's going up to 15. The courts generally don't even want lawyers in the courtroom necessarily. Although I don't think they would object to it necessarily. But you don't have to hire a lawyer. But the real underlying question is the beginning of the question. I just received a frivolous lawsuit. Well, just because you were sued doesn't necessarily mean it was frivolous. So, and all the answers apply regardless of the validity of the lawsuit.
Well, if I decide to go without a lawyer, Judge Hilden, and try to handle a case myself, how do I educate myself or research on how I can deal with that kind of problem without having to pay a lawyer?
Boy, it's really tough. We have people, as Sean said, in conciliation court and sometimes even in regular district court, trying to represent themselves. What I tell litigants is you will have to abide by all the usual rules of civil procedure, rules of evidence, all the things that lawyers are expected to abide by. And if you've never studied it, you don't even know where to look for them, it makes it really tough to represent yourself. An individual does have the right to represent themselves, but if you don't have insurance coverage, can't afford a lawyer, there are places to go where you can get a little bit of advice or have an attorney help you with the process of responding to that lawsuit.
Why don't the judges just throw these cases out of court before it's necessary to spend time or money on them, Judge Kuzo?
Well, I think sometimes the judges and the court system generally allows the parties to conduct discovery, to exchange information, to determine what the facts are that are developing or that need to be developed in order for one side to establish exactly what their claim is about. To just jump in and think that it's a frivolous lawsuit because it may not look fully developed in the beginning may not be appropriate, because the parties need that time to be able to exchange information. Once that information is exchanged, that might be a more appropriate time to for one of the parties to bring an appropriate motion before the court to ask for some type of relief, if in fact they've got all the information they need and still believe that that claim is frivolous or has no legal basis for it.
There are some cases that can be disposed of on the front end. It's what we call a Rule 12 motion. And they're things like if you miss the statute of limitations, or you have a legal theory that doesn't exist, but it's really kind of a rare case that qualifies for that sort of dismissal.
Well, other than the Rule 12 motion, Sean, can you tell us, once a lawsuit has started and is in the stages that Judge Kuzo just described to us, what tools does a lawyer have to use to seek a dismissal of any case that's not legitimate?
Well, as Judge Kuzo said, we might go through a process called discovery, where we exchange information, and then the party who wants to get the case dismissed can make what's called a summary judgment motion under Rule 56, asking the court, hey, here are all the facts, we've developed them, and there just isn't a legal basis for this, and ask the judge to throw out the case. And I think it's also important to note, if a lawyer started the lawsuit on behalf of the plaintiff, the lawyer has to sign as part of the complaint, at the bottom of the complaint, almost an affidavit, as it were, saying, I've investigated this, and I am telling you, I believe, I have a fair basis to believe that this lawsuit is legitimate. And if that lawyer didn't do that, didn't actually investigate it, then that lawyer is subject to all kinds of sanctions that the judges can bring against that lawyer for bringing a lawsuit that had no merit.
No, and can I add this in as well? Sure. The summary judgment that Sean was talking about, there's really two things that have to happen, or that we have to be satisfied when we hear the motion. And the first is kind of the most important one, and that is that there isn't any dispute of material fact.
What's that mean?
So that means that there isn't anything that a jury should have to decide. So let me take the example of intersection accident between two cars. You know for a fact that you had the green light, but if that other person sues you and says they had the green light, there's a fact dispute there, and a jury's going to have to decide between the two of you. Now, you may think that's a frivolous lawsuit because you know you had the green light, but it's up to that jury to decide who's liable for the case.
Okay, so let's take a situation. I'll ask you this one, Judge Kuzo. Let's pretend that instead of an intersection collision, like Judge Hilden just described, I rear-end your vehicle while you're in it. And then I sue you for negligence. Would that be a frivolous lawsuit?
It may or may not be, depending upon other facts that probably need to be determined. Maybe it was at night, and maybe the taillights on my vehicle weren't operating, and because of that you ended up rear-ending me. On the other hand, if it was in the middle of the day and everybody admits that everything was functioning appropriately and there's no reasonable explanation as to what I may have done wrong, being the car in front, that caused you to rear end me, those facts might not be disputed. There's no material facts that are in question. That might be appropriate for a judge to make a determination that summary judgment or deciding the case without a jury trial is appropriate.
So if so, and it was in broad daylight and I don't have any evidence you did anything wrong before I ran into the back end of your car, I could get tossed out of court before I see a jury.
Yep.
Now, I think most of us learned in civics that everybody in the United States has a right to have their case tried by a jury. Sean, is what the judge just said contrary to the constitutions of the state of Minnesota and the United States?
Well, no, of course not, because it's a case that has a basis. There still has to be a basis to go forward. And, Judge Kuzo described two scenarios. One, well, there's a dispute as to whether or not he did anything wrong, even though he was the one rear-ended, or one where there's no dispute. He did nothing wrong. If there's no dispute, there's no case. The jury makes a decision on disputed facts, not things that are not in dispute. And the law still is the law. And if the law says you have to have a valid basis to collect money, for example, due to somebody's negligence, and you can't prove that that person is negligent at all, then there is no case. There is no case.
And keep in mind, there's some cases that will have many different issues in dispute.
Oh, yeah.
So in his case, maybe there isn't a question on liability because he didn't do anything wrong, but there is a question about damages that a jury has to decide.
Whether somebody was hurt.
Or the extent of their injuries.
And just expanding a bit on what Sean said, the Seventh Amendment to the Constitution is that amendment that gives people the right to a jury trial. And that specific amendment talks about the jury's role, which is to determine the facts in the case. Not just to determine whether somebody should be awarded some money, but what the facts are. So if the facts, in fact, are not disputed, that right to a jury trial doesn't need to be preserved because there's nothing for a jury to decide.
This may seem like a change of topic, but it really isn't. Are there too many lawsuits? I'll start with you, Judge Hilden. President Bush seemed to be saying that there were back when he made his State of the Union speech in 2005. What do you think?
Well, actually, we had a show on this last year, didn't we? The death of the civil lawsuit.
Yeah, I think we did, yeah.
And the number of lawsuits, at least in the Duluth courthouse, have gone down kind of precipitously since you and I were younger lawyers. Mm-hmm. We've actually been a pilot project courthouse for what we call the rocket docket, which means that we're going to get your case to trial within 4 to 6 months after it's filed. So we're trying to get, if people want to have jury trials, they can certainly have them here in the Duluth courthouse.
Okay. Judge Kuzo, you're in the same judicial district, but you're in two different courthouses than the one Judge Hilden minds. Have you noticed that there's any change in the number of lawsuits that are routinely filed or that are tried these days between people in your courthouses?
With respect to civil lawsuits, I don't see a lot of civil cases tried. I mean, it seems to be a small percentage of the overall number of trials that are conducted in both Cook and Lake County. I don't think I have the very lengthy base of knowledge. I've been a judge for 5 years, which is pretty short, actually, in comparison with Judge Hilden and the other judges in the district. But overall, I don't see the number of civil cases as being extraordinary in any respect.
Well, I don't want to overlook Sean, but this brings up another question. I know you're both very, very busy judges. If there aren't a lot of civil disputes between private citizens being tried in your courtrooms, what do you spend your time doing? Judge Hilden, why don't you tell the viewers what you do with your time?
At least half of what every judge does is criminal work.
Okay.
It's just really the bulk of, and it's kind of strange because the crime rate has gone down since, let's say, the 1970s, 1980s. Serious crime has gone down, but there's still, that is the bulk of the work that we see in the Duluth courthouse.
Okay, and then the rest of your time's taken up with family law disputes?
Oh, yeah. And in Duluth, the 8 judges in the Duluth courthouse all do every type of case. So we'll do criminal, probate cases, divorces, adoptions, child protection cases, harassment, restraining orders, orders for protection, civil lawsuits. It really runs the gamut.
Now, Judge Kuzo, Judge Hilden is in a courthouse with 7 other judges. You aren't. You're in 2 courthouses. How many other judges help you with your 2 courthouses?
Typically, I am the judge that people get in those 2 courthouses, except on rare occasions where I might have a conflict. I might know one of the parties and I remove myself. Sometimes parties might have the right or exercise the right to select a different judge or to remove me from a particular case, in which case other judges will come up and handle those cases. Third, sometimes there are emergent cases that need to be heard on short notice, and if I happen to be in Cook County handling cases and there's a case that needs to be heard on very short notice in Lake County, typically judges from Duluth will handle those cases. So I do have good backup from many of the other judges within the district.
Is the mix of cases you see roughly similar in amounts and percentages to what Judge Hilden described, or different?
Generally, I think that's true. My estimate would be that I'm guessing 60 to 65% of what I do are criminal cases, maybe 25% being family law and juvenile child protection cases, if you want to consider that as part of dealing with family units generally, and then a smattering of other cases that might be equally mixed.
Okay.
And if I can add on to the 2 answers, Jim, Justice Gildy issues, she's the Chief Justice of the Supreme Court, she issues an annual report, and there's statistics broken down by the entire state and by each judicial district. And I brought the one that she has for our 6th judicial district, and last year, 2015, there were about 48,000 cases filed. That doesn't necessarily mean there was a trial, but there was 48,000 filings.
That's Cook, Lake, St. Louis, and Carleton counties?
Right.
Okay.
And over 30,000 of them were minor criminal cases, which is about 2/3 of them.
Misdemeanors.
Misdemeanors. That takes up the majority of the filings. Criminals, another 3,500. Then you got minor civil, juvenile, family, major civil, car accident cases. Next to last, as far as use, no only thing behind it is probate. So it's a rare chance, as you guys discussed last year, to have a civil trial.
Well, I have a question from a viewer, and I'll ask Judge Hilden. Someone files a lawsuit on several different issues. The man filing the lawsuit is a known liar, a known criminal. That's the question. Would a judge be inclined to dismiss claims by a known criminal, a known liar?
I would say no.
Really?
Everyone gets to tell their story. That's one of the things about our system. So let's go back to my intersection accident case. Let's say it's the known liar who is filing the lawsuit to say, I had the green light and the other guy hit me. It's still up to the jury to say, we don't believe him. It's not up to me as the judge to say, oh, wait a minute. We know that you're a known liar and a criminal, therefore we're going to throw your case out.
So even a liar has his day in court. Okay.
Unless, I will add this, unless it's a known serial lawsuit liar. And by that I mean a guy who files the lawsuit and then files it again and again and again and again. The courts do have the power to say, I'm not letting you file any lawsuit unless I review it first and make sure that there's at least some reasonable basis to proceed ahead with that.
Okay. Now here's another question that sort of goes to the other side of the question of frivolous lawsuits. Judge Kuzo, this question is, what are the biggest obstacles you see in keeping the courts available to the public, to the citizens to use to get their grievances adjusted or adjudicated?
Well, I think it's that breakdown of the other types of cases that we handle within the judicial district that we already talked about. The fact that we're spending 50 to 60 to 70% of our time handling criminal cases. We've got family law cases, child protection cases, which have some urgency to them. They need to be resolved so the problems within the family units can be dealt with in an appropriate fashion. Sometimes as a result of that, it gets difficult to schedule as much time as perhaps everybody would like to deal with the civil cases that people want to see move through their system. That's probably the biggest obstacle. We still try to make sure that the cases are handled in what we consider an appropriately timely fashion, but that may end up being a little bit longer than anybody would like.
See, now, we're both kind of from the civil area.
Yes.
When we were lawyers. I love civil cases. I'd do civil cases all the time if I could, but that isn't kind of what the business is.
Well, I understand tonight's topic is litigation safeguards, but just to help the viewers understand how this works, are there similar remedies available to deal with what a criminal defendant believes to be an unjust charge made against him? Is there anything he can do to get rid of a case before he has to go before a jury with it? Judge Kuzo.
They certainly have some of the same protections. They might be phrased slightly differently, but a criminal defendant could ask that the state's case be dismissed for lack of having probable cause or enough of a basis to proceed with that case. That would be similar to what we would call a summary judgment motion in a civil case.
Okay. Now, Sean, I've got a question about some of these other remedies that I've been hearing about. And one of them is, I think, punitive damages. I think we've all heard the businesses of America claim that punitive damages are strangling American enterprise. Is there something in Minnesota that businesses can do to protect themselves from some sort of a shakedown by a plaintiff who just claims punitive damages in an effort to get a quick settlement for a few bucks?
Yeah, in Minnesota that doesn't happen. It can't happen
Why is that?
by law. No lawsuit can seek punitive damages in the state of Minnesota with some very, very rare exceptions. If you want to make a claim for punitive damages, first you start the lawsuit. Then you go through the process of discovery where you're exchanging information. And then you ask the judge, so I go to Judge Kuzo, I go to Judge Hilden, and I say, Judge, here is some evidence I have that shows that the defendant's behavior was absolutely, totally egregious, so unlawful, so harmful. And we ought to at least let a jury decide whether or not the behavior was so bad that punitive damages might be awarded. And then the judge has to review that and decide, yeah, I think there could be a case here, or no, that's still not bad enough, and I'm not going to even allow a jury to decide it. So that's required by law in Minnesota. From time to time, people will see on the internet, on the newspaper, online, somebody files a lawsuit for $50 million or something like that. That does not happen in Minnesota. We don't allow that kind of stuff in Minnesota.
Yeah, like the Hulk and,
Yeah.
well, never mind.
Yeah.
Okay, let's move. Let's go. I have one more question. Speaking of punitive measures, and I'll start with you, Judge Hilden. What kinds of things can a judge do where he learns that the lawyer who signed the pleadings and certified that the case was a case he brought only after investigating the facts and the law, and the court becomes convinced that he failed to make an adequate investigation? what kind of sanctions are available? Are they real?
The judge can make a complaint to the Office of Lawyers' Professional Responsibility if he feels there's been an ethical breach. Judge can also dip into what we call Rule 11, which is you signed a pleading without a good faith basis behind it.
Okay. And then here's a good question. Judge Kuzo, have you ever encountered such a situation since you've been on the bench?
You know, one of the things I'm really proud of is I think we have a very good active bar. I mean, the members of the attorneys that practice up here. I can't recall a case that I felt just needed to be dismissed out of hand like that.
Okay. Well, thank you. That's all the time we have. I want to thank our panelists. Remember, you can watch this show again online at wdse.org or on the Falsani, Balmer, Peterson, Quinn, and Beyer website. Please join us again next week when we answer your questions about workers' compensation. I'm Jim Balmer. Good night.